I knew something was wrong the moment I turned onto the long dirt road that led to my property in rural Georgia, and saw nothing but sky where there should have been a wall of green. My chest tightened as I accelerated, gravel crunching under the tires of my truck, dust billowing behind me. When I reached the clearing where my cabin sat, I slammed on the brakes so hard the seatbelt cut into my shoulder. 50 acres. 50 acres of prime timber forest that had surrounded my property like a protective embrace was gone. Not trimmed, not thinned. Gone. Clear cut down to stumps and sawdust, leaving behind a wasteland that looked like a bomb had gone off. The mature oak trees my grandfather had planted were reduced to nothing. The hickory and pine that had taken decades to grow were erased. I sat there in my truck, engine still running, staring at the devastation with my mouth hanging open. I had only been gone for 3 weeks, visiting my daughter in Colorado after her surgery. 3 weeks, and someone had destroyed half a century of growth. My name is Samuel Pierce, and I'm a 47-year-old carpenter who inherited this land from my father when he passed 5 years ago. The property itself was about 75 acres total in Gilmer County, tucked away in the mountains where most people valued privacy and natural beauty. I had built my cabin with my own hands, using timber from the property when necessary, always selective, always respectful. The forest was not just an asset, it was part of my family history. I killed the engine and stepped out onto what used to be the edge of my wooded paradise. The silence was eerie. No rustling leaves, no bird calls echoing through the canopy because there was no canopy left. Just open air and the smell of fresh cut wood and diesel fuel. That was when I noticed the tire tracks. Heavy equipment had torn through here, multiple vehicles, creating deep ruts in what used to be soft forest floor covered in decades of leaf litter. I followed the tracks with my eyes and saw they led back toward the main road, but also toward the newer development that had sprung up about a mile east of my property. Cascade Ridge Estates. A planned community that had been built 3 years ago, complete with a homeowners association that I had successfully avoided by being just outside their boundaries. My property was deliberately separate, grandfathered in, with clear legal boundaries that predated their development by generations. I pulled out my phone and started taking pictures, documenting everything I could see. The stumps were fresh, oozing sap, the cuts clean and professional. This was not some random act of vandalism. This was a logging operation, organized and executed with expensive equipment. My hands were shaking as I walked the perimeter of the destruction. Every step revealed more loss. The old oak where I had built a treehouse for my daughter when she was 6, gone. The cluster of hickories that produced nuts every fall, gone. The pine grove where I collected firewood, decimated. I was standing in the middle of the wasteland, trying to process the scope of what had happened, when I heard a car approaching. A white sedan with a Cascade Ridge Estates logo on the door pulled up next to my truck. A woman in her mid-50s stepped out, wearing a cream-colored pantsuit that looked absurdly out of place in the destruction zone. Her blonde hair was styled in that particular way that screamed, "I need to speak to the manager," and she was carrying a tablet like it was a weapon. "Mr. Pierce," she said, her voice dripping with false sweetness, "I am Patricia Cunningham, president of the Cascade Ridge Estates Homeowners Association. I'm glad you are finally back. We need to discuss your property." I stared at her, then at the devastation around us, then back at her. "You need to discuss my property?" "Lady, what the hell happened here? Who authorized this?" Patricia's smile did not waver, but her eyes went cold. "The HOA board conducted a thorough review of the area and determined that your overgrown forest posed a significant fire hazard to our community. We have the authority to mitigate dangers within our jurisdiction." "Your jurisdiction?" I took a step toward her, fists clenched at my sides. "This is my property. I am not part of your HOA. I am not even in your development. You had no right to touch a single tree here." She tapped something on her tablet with one perfectly manicured nail. "Actually, if you check the county records, you will find that a boundary adjustment was filed 6 months ago. Your eastern property line was determined to encroach on HOA common areas by approximately 50 acres. We simply exercised our rights to manage that land appropriately." My vision actually blurred for a second. Boundary adjustment? I never agreed to any boundary adjustment. That is impossible. The county records speak for themselves, Patricia said, her tone now openly condescending. Furthermore, the timber removal has already been processed as revenue for the HOA. The logging company paid us $45,000 for the harvest rights, which will go toward community improvements. You should be thanking us for removing the fire hazard at no cost to you. I could not believe what I was hearing. You cut down my trees, sold my timber, and you think I should thank you? Former trees on former property, she corrected. Now, there is also the matter of the cleanup costs. The HOA will need to send you a bill for our administrative time in arranging this project. I estimate around $5,000 should cover it. For a moment, I actually could not speak. The sheer audacity of this woman standing in the ruins of my forest, telling me I owed her money for the privilege of having my land destroyed, was beyond comprehension. Get off my property, I finally managed, my voice low and dangerous. Get off right now and tell me the name of your HOA attorney because you are about to get sued into oblivion. Patricia actually laughed. Mr. Pierce, I understand you are upset, but threatening legal action against an HOA is rarely productive. We have lawyers on retainer and a very healthy legal defense fund. You are a single homeowner. Do the math. She turned to leave, then paused. Oh, and you will be receiving a citation for the unsightly stumps. They are an eyesore and violate our community standards. You have 30 days to have them ground down and the area landscaped to HOA specifications. She got back in her car and drove away, leaving me standing in the devastation, so angry I was trembling. I spent the next hour walking every inch of the destroyed area, taking hundreds of photos and videos. I documented every stump, every tire track, every piece of evidence I could find. I also walked my property boundaries, checking the survey markers my father had placed years ago. They were exactly where they had always been, and they clearly showed that the logged area was well within my property lines. Back in my cabin, I dug through my filing cabinet until I found the original property deed and survey documents. Everything was in order, recorded properly with the county, showing exactly what I knew to be true. This land was mine, all of it, and had been for generations. I grabbed my laptop and pulled up the county property records online. What I found made my blood run cold. Someone had indeed filed a boundary adjustment 6 months ago, claiming that a new survey had revealed errors in the original property lines. The filing showed my signature on the documents. I had never seen those documents before in my life. I certainly had never signed them. This was not just a property dispute. This was fraud. They had forged my signature, filed false documents with the county, stolen my timber, and were now trying to extort more money from me for the privilege. I picked up my phone and called the first attorney I could find who specialized in property law. His name was Michael Rodriguez, and his office was in Ellijay, about 20 minutes away. His receptionist said he could see me first thing Monday morning. It was currently Friday afternoon. The weekend crawled by at an agonizing pace. I could not sleep, could not eat, could barely function. Every time I looked out my window, I saw the wasteland where my forest used to be. I kept taking photos, documenting everything from every angle. I also started researching timber trespass laws in Georgia. What I found gave me the first glimmer of hope since this nightmare began. Georgia has something called the Timber Trespass Act, which provides for triple damages when someone unlawfully cuts timber on another person's property. If the trespass is willful and intentional, the damages are tripled automatically. And if the person who cut the timber sold it, you could recover the value of the timber plus additional penalties. $45,000, Patricia had said. Triple that would be $135,000, plus attorney fees, plus the cost of reforestation, plus punitive damages for the fraud. By the time Monday morning arrived, I had a folder 3 inches thick with documentation, research, and photographs. Michael Rodriguez's office was in a small brick building downtown, decorated with law books and certificates that suggested he had been practicing for over 20 years. Michael himself was a man in his early 50s with graying hair and a firm handshake. He listened to my story without interrupting, occasionally making notes on a legal pad. When I finished and showed him the documentation, he let out a low whistle. Mr. Pierce, this is one of the most egregious cases of timber trespass I have seen in my career, he said, and the forged documents make it even worse. This is not just a civil matter, this is potentially criminal fraud. Can we win? I asked. Win? He leaned back in his chair. If everything you are telling me is accurate and these photos and documents are legitimate, we are not just going to win. We are going to bury them. Timber trespass in Georgia is taken very seriously, especially when it involves this much acreage and this much value. But I need to verify a few things first. Over the next week, Michael worked like a man possessed. He obtained the official county records, hired a forensic document examiner to analyze the forged signature, commissioned a new property survey from an independent surveyor, and consulted with a timber expert to assess the true value of what had been taken. The results were even worse than I had thought. The timber expert, a man named John Whitfield, who had been appraising forests for 30 years, estimated that the actual value of the timber removed was not $45,000, but closer to $90,000. The HOA had either drastically undervalued it to avoid taxes or had pocketed the difference. Either way, it was theft. The forensic document examiner confirmed that the signature on the boundary adjustment documents was forged. It was not even a good forgery, apparently, just close enough to pass a casual inspection by a county clerk who processed hundreds of documents a month. The new survey confirmed what I already knew. My original property boundaries were correct, and the 50 acres of timber had been entirely on my land. Armed with this evidence, Michael filed a lawsuit in Gilmer County Superior Court. The complaint was a thing of beauty, 50 pages of legal precision that laid out every violation, every law broken, every dollar stolen. We sued the HOA, Patricia Cunningham personally, the HOA board members, and the logging company that had cut the trees. We asked for triple damages under the Georgia Timber Trespass Act, which brought the timber value to $270,000. We asked for punitive damages for the fraud. We asked for attorney fees. We asked for the cost of reforestation and restoration. We asked for damages for emotional distress. By the time Michael was done, the total claim was over $500,000. We also filed a criminal complaint with the Gilmer County Sheriff's Department regarding the forged documents. The reaction was immediate and explosive. 3 days after the lawsuit was filed, I got a call from a different attorney, a man named Richard Blackstone, who represented the HOA. His tone was conciliatory, almost friendly. "Mr. Pierce, I think there has been a terrible misunderstanding," he said. "I have reviewed the situation, and it appears there may have been some administrative errors on the part of the HOA. My clients are willing to offer a settlement to resolve this matter quickly and quietly." "I am listening," I said, even though Michael had coached me to say as little as possible. "The HOA is prepared to offer you $50,000 to cover any inconvenience and to drop the lawsuit. We think that is more than fair compensation for what was essentially a boundary dispute." I actually laughed. "Your client stole timber worth $90,000, and you are offering me $50,000. Tell Patricia she can take that offer and shove it somewhere the sun does not shine." "Mr. Pierce, I do not think you understand the situation. The HOA has substantial resources and very good legal representation. This could drag on for years. You will spend a fortune on attorney fees, and even if you win, collecting the judgment could be nearly impossible. Take the settlement. It is the smart play." "Here is my counteroffer," I said. "Triple damages plus all my attorney fees, all my expert witness fees, the cost of reforestation, a formal written apology from Patricia Cunningham published in the local newspaper, and her resignation from the HOA board. Oh, and criminal charges against everyone involved in the forgery. Take it or leave it." There was a long silence. "That is not a realistic negotiation position." "Then I will see you in court." I hung up. Michael called me that evening, sounding both amused and impressed. "I heard you turned down their settlement offer. $50,000 for $90,000 worth of timber they stole? That's insulting." "It is insulting," he agreed, "but I need to make sure you understand what you are getting into. This is going to be a fight. They are going to make it ugly. They are going to try to drag your name through the mud, question your property claims, maybe even dig into your personal life looking for ammunition. Are you prepared for that?" I looked out my window at the devastation that used to be forest. I am prepared to take this as far as it needs to go. Good, because it is about to get interesting. Interesting was an understatement. Over the next month, the HOA's legal team went on the offensive. They filed a motion to dismiss the lawsuit, claiming that the Timber Trespass Act did not apply because the boundary dispute was legitimate. They filed counterclaims alleging that I had been encroaching on HOA property for years and demanding compensation. They sent letters to everyone in the Cascade Ridge Estates development, warning them that my lawsuit was threatening their property values and trying to rally opposition against me. But Michael was ready for all of it. He filed detailed responses to every motion, backed by expert testimony and documentation that was irrefutable. The judge, a woman named Sandra Mitchell, who had a reputation for not tolerating nonsense, denied the motion to dismiss and ordered the case to proceed to discovery. Discovery was where things really started to fall apart for the HOA. Michael issued subpoenas for all HOA records related to the logging operation, all communications between board members, all financial records showing how the $45,000 had been spent, and all documents related to the boundary adjustment filing. What we found was damning. Email chains between Patricia Cunningham and other board members showed that they had known all along that the timber was on my property. They had discussed the boundary dispute strategy as a way to claim the timber legally after the fact. One email from Patricia literally said, "Pierce is out of town for weeks. If we move fast, we can harvest the timber and create the paperwork trail before he even knows what happened. By the time he gets back and figures it out, we will have possession being 9/10 of the law on our side." Another email chain showed that the logging company had actually paid $70,000 for the timber, not $45,000. The HOA had pocketed the difference in an undisclosed account. We also found records showing that Patricia had hired her cousin, a notary public, to notarize the forged boundary adjustment documents without my being present, which was itself illegal. Michael filed an amended complaint adding RICO charges, fraud, conversion, and about 6 other causes of action. The case was no longer just about timber trespass. It was about a conspiracy to commit fraud. The criminal investigation was also moving forward. Detective Sarah Martinez from the Gilmer County Sheriff's Department was handling the case, and she was thorough. She interviewed the logging company, which immediately threw the HOA under the bus, providing documentation showing that Patricia had approached them, offered them the job, and assured them all permits were in order. The logging company had done their own due diligence and found what they thought were legitimate county records showing the boundary adjustment. The notary public, when confronted with evidence of the illegal notarization, broke down and admitted that Patricia had paid her $2,000 to stamp the documents without verifying my identity. She was charged with notary fraud, a misdemeanor, but she also agreed to testify against Patricia and the HOA board. By late spring, the case was ready for trial. The HOA made one more settlement offer, this time through a mediator. They offered $200,000 and Patricia's resignation. Michael presented the offer to me over lunch at a small diner in LEJ. "It is not a bad offer," he said carefully. "It is less than we asked for, but it is substantial, and it is guaranteed. If we go to trial, there is always risk. Juries can be unpredictable." I thought about it for a long time. $200,000 was life-changing money. I could rebuild, replant, maybe even come out ahead financially. But it was not about the money anymore. It was about what they had done and what they thought they could get away with. "No," I said finally. "We go to trial. I want a jury to hear what they did. I want it on public record. I want everyone in that development to know exactly what kind of people are running their HOA." Michael nodded slowly. "All right then, let's go to war." The trial began on a Tuesday morning in June. The Gilmer County Courthouse was a stately building with tall ceilings and wood paneling that had seen generations of justice dispensed within its walls. Judge Mitchell presided with an air of stern impartiality, and the jury box filled with 12 citizens who would decide the case. Michael's opening statement was powerful and clear. He laid out the facts methodically, showing the jury photos of the destroyed forest, the forged documents, the email chains proving conspiracy, and the financial records showing the theft. He made it simple and straightforward. The defendants had knowingly and deliberately stolen $90,000 worth of timber from my property, forged legal documents to cover their tracks, and then tried to extort more money from me. The HOA's attorney, Richard Blackstone, tried a different approach. He painted the situation as a tragic misunderstanding, an innocent boundary dispute that had spiraled out of control due to miscommunication and administrative errors. He portrayed Patricia Cunningham as a dedicated volunteer trying to protect her community from fire hazards, not a criminal mastermind. He suggested that I was exaggerating the value of the timber and the extent of the damages to extract a windfall payment from a nonprofit organization. It might have worked if we had not had the emails. Michael called witness after witness over the next week. The forensic document examiner testified that the signature was definitely forged and showed the jury the differences. The timber expert walked through his appraisal, explaining how he calculated the value of each tree species, the age of the timber, the market rates, and why the actual value was $90,000, not $45,000. The surveyor testified that my property boundaries were correct and had been for over 100 years. The notary public, looking miserable and ashamed, testified about how Patricia had paid her to illegally notarize the documents. Then, we played the emails in court. Michael had them printed on large poster boards so the jury could read along as he read them aloud, watching the jurors' faces as they heard Patricia's own words about moving fast before I got back, about creating a paperwork trail, about possession being 9/10 of the law was like watching a storm roll in. Their expressions went from curious to shocked to angry. The HOA's defense fell apart in real time. Richard tried to claim the emails were taken out of context, but there was no context that could explain away, if we move fast, we can harvest the timber and create the paperwork trail before he even knows what happened. When Patricia took the stand, Michael cross-examined her for 3 hours. She was evasive, condescending, and completely unable to explain away the evidence. At one point, she actually said, "I was trying to protect property values in our community. Sometimes that requires making tough decisions." Michael pounced. "Tough decisions like forging Mr. Pierce's signature on legal documents?" "That was a clerical error," she stammered. "A clerical error that involved hiring your cousin to illegally notarize those documents? A clerical error that you paid her $2,000 to commit?" She had no answer. I testified on the last day of the trial. Michael kept it simple, asking me to describe my relationship with the land, what the forest meant to me, what I felt when I came home and saw it destroyed. I told the jury about my grandfather planting those oaks, about building the treehouse for my daughter, about the 50 years of family history that had been erased in 3 weeks. By the time I finished, 2 of the jurors were wiping their eyes. Closing arguments were powerful on both sides, but the evidence was overwhelming. The jury deliberated for less than 4 hours before returning with a verdict. Guilty on all counts, triple damages under the Georgia Timber Trespass Act, $270,000, punitive damages for fraud, $100,000, attorney fees and costs, $80,000, reforestation and restoration costs, $50,000, total judgment, $500,000. The courtroom erupted. Patricia looked like she had been slapped. Several HOA board members who had been sitting in the gallery looked like they might be sick. Michael squeezed my shoulder and whispered, "We did it, but we were not done yet." The criminal charges were still pending. 2 weeks after the civil trial ended, Patricia Cunningham and 2 other HOA board members were arrested and charged with fraud, forgery, and conspiracy to commit fraud. The notary had already pleaded guilty to notary fraud and received probation. Patricia's criminal trial was scheduled for September. She tried to negotiate a plea deal, but the district attorney, a no-nonsense woman named Catherine Brooks, was not interested in being lenient. Patricia had thought she could use her position and her HOA's resources to steamroll a single homeowner. She had thought she was untouchable. The criminal trial was shorter than the civil trial because the evidence was already established. Patricia was convicted on all charges and sentenced to 3 years in prison, followed by 5 years of probation. The other board members received lighter sentences, 1 year each, plus substantial fines and community service. The HOA itself was in freefall. The $500,000 judgment bankrupted their reserves and forced them to levy a special assessment on all homeowners in Cascade Ridge Estates. Each household had to pay over $3,000 to cover the judgment. Property values in the development tanked as word spread about the scandal. Several board members resigned in disgrace. The development tried to distance itself from Patricia and the others, issuing statements about new oversight and reformed governance, but the damage was done. Meanwhile, I was working on rebuilding. The $500,000 was more than enough to cover everything. I hired a reforestation company to clear the stumps, prepare the soil, and plant new trees. Thousands of saplings went into the ground that fall. Oaks, hickories, pines, all native species that would eventually restore what had been taken. It would take decades for them to reach maturity, but at least it was a start. I also used some of the money to install security cameras around my property and to hire a lawyer to review all my property documents and ensure everything was properly recorded and protected. I was not going to let this happen again. The logging company settled separately for an undisclosed amount. They had not been part of the conspiracy, but they had failed to do adequate due diligence, and they did not want the publicity of another trial. By the time autumn arrived, the worst was behind me. The stumps were gone, the new trees were planted, and my property was secure. The criminal trials were over, the judgments were paid, and the people responsible were facing consequences. One crisp October afternoon, I was standing on my porch, looking out at the field of saplings that represented the future forest, when I heard a car approaching. For a second, my stomach clenched, worried it might be more trouble. But it was just my daughter Emma's car, a little blue sedan that I recognized immediately. She got out with her husband Mark and their 2 kids, my grandchildren, who immediately started running around the property with the boundless energy only children possess. Emma walked up to the porch and gave me a hug. "The trees are looking good, Dad," she said, gesturing at the saplings. "They will take time," I said, "but they will grow." I heard Patricia is appealing her sentence. She can appeal all she wants. It is not going to change anything. She committed fraud, got caught, and now she is paying for it. Emma smiled. "You know, when you first told me what happened, I was so angry I could not see straight. But you handled it exactly right. You did not take their insulting settlement offer, you did not back down, and you made sure there were real consequences." "I did not have much choice," I said. "They thought they could just take what they wanted because they had an HOA behind them. They thought one guy would not fight back. But you did." "Yeah," I said, watching my grandkids chase each other around the saplings. "I did." We spent the rest of the afternoon together, cooking dinner on the grill, telling stories, and enjoying the peace that comes from knowing justice was served. The forest would grow back eventually. It would not be the same as what my grandfather planted, but it would be mine, and it would be protected. That evening, after Emma and her family left, I sat on my porch with a beer and watched the sun set over my property. The saplings were just dark silhouettes against the orange sky, fragile and small, but full of potential. In 50 years, they would be a forest again. Maybe my grandchildren would bring their children here to play among those trees. Patricia Cunningham was in prison. The HOA board was in disgrace. The homeowners of Cascade Ridge Estates were stuck with a massive special assessment and plummeting property values. And I was sitting on my porch, on my land, victorious. The whole experience had taught me something important about power and abuse. HOAs can be useful organizations when run properly, managing common areas and maintaining community standards. But they can also become petty tyrannies when the wrong people get control, when board members start thinking they are above the law, when they forget that they are stewards, not owners. Patricia had forgotten that. She had thought her position gave her the right to do whatever she wanted, to steamroll anyone who stood in her way, to forge documents and steal property and face no consequences. She had been spectacularly wrong. The Georgia Timber Trespass Act exists precisely because timber theft used to be a major problem in rural areas. Trees take decades to grow, but only hours to cut down. The value is substantial, and the temptation for theft is real. The law provides triple damages specifically to deter this kind of conduct, to make it so expensive to steal timber that nobody would dare try. Patricia had dared, and it had cost her everything. Her freedom, her reputation, her position, and $500,000 of the HOA's money. It was a cautionary tale that would be told in Gilmer County for years to come. Over the following months, I received several calls from other property owners in Georgia who had similar disputes with HOAs or neighbors. Word had spread about my case, and people wanted to know if they could do the same thing. I always told them the same thing: document everything, hire a good lawyer, and do not back down if you know you are right. The law is on the side of property owners, but you have to be willing to fight for it. I also received a surprising call from a journalist at the Atlanta Journal-Constitution who wanted to write a story about the case. The article came out in November, a detailed investigation into HOA abuses in Georgia, and how my case had exposed systemic problems with oversight and accountability. The story quoted legal experts who said that timber trespass cases like mine were becoming more common as developments expanded into rural areas, and HOAs tried to exert control over properties that were not actually part of their jurisdiction. The article generated more publicity, which led to calls from state legislators interested in reforming HOA laws to prevent future abuses. I testified before a Georgia House committee in January, telling my story and explaining how easy it had been for Patricia to forge documents and file fraudulent boundary adjustments with minimal oversight. Several representatives seemed genuinely shocked by what had happened and promised to look into stronger regulations and criminal penalties. By the spring of the following year, the Georgia legislature passed new laws requiring additional verification for boundary adjustments, stricter penalties for forged property documents, and enhanced oversight of HOA financial transactions. The bill was nicknamed Pierce's Law in the media, though that was not the official title. I attended the signing ceremony at the governor's office, and several legislators thanked me for bringing the issue to light. It was strange to think that my personal nightmare had led to changes that might protect other property owners in the future. But it felt right. Something good had come from something terrible. Meanwhile, life went on. The saplings grew steadily, gaining a few inches each month. I tended them carefully, making sure they had adequate water during dry spells, protecting them from deer with fencing, and monitoring their health. Reforestation is a long-term project, requiring patience and dedication, but I had both. I also rebuilt my relationship with my immediate neighbors, most of whom had nothing to do with the HOA disaster and had been sympathetic from the start. There was an older couple about a mile north, the Johnsons, who had lived in the area even longer than my family. Mrs. Johnson brought me a casserole when the trial ended and told me she was proud of how I had stood up to the HOA. "Those people thought they owned the whole county," she said. "You showed them different." There was also a younger family to the south, the Martins, who had moved in a few years ago specifically to get away from HOA restrictions. They had 2 teenage boys who sometimes helped me with property maintenance in exchange for letting them use my land for hiking and camping. When they heard about what happened, both boys volunteered to help plant saplings. We spent a weekend together getting a particularly steep section planted, and it was good to have the company and the help. The Cascade Ridge Estates development, meanwhile, continued to struggle. The special assessment had been deeply unpopular, and several homeowners had filed their own lawsuits against the HOA, seeking to dissolve the organization entirely or at least replace the leadership. Property values remained depressed. Several homes went into foreclosure as owners walked away from the debt. The development, which had been marketed as a premium mountain community, became known as the place where the HOA had committed fraud and bankrupted itself. I would be lying if I said I did not take some satisfaction in that. They had tried to destroy me and ended up destroying themselves instead. There is a certain poetic justice in consequences coming home to roost. Patricia served 2 years of her 3-year sentence before being released on parole. I heard through the grapevine that she had moved out of state, unable to face the community she had disgraced. Her husband had divorced her during the trial, and her adult children had reportedly cut off contact. She lost everything, which seemed appropriate given what she had tried to take from me. The other board members faded into obscurity, their reputations ruined, their time served. The notary public lost her license permanently and ended up working retail in another county. The logging company went out of business, unable to overcome the publicity and the settlement costs. Sometimes I think about how different things could have been if I had just accepted that first $50,000 settlement offer. I could have taken the money, replanted the trees, and moved on with my life without the stress and expense of litigation and criminal trials. Part of me wonders if it would have been easier. But then I look at the laws that changed, at the other property owners who reached out to say my case helped them stand up to similar abuses, at the fact that Patricia and her cronies actually faced criminal consequences instead of just walking away with a slap on the wrist. And I know I made the right choice. Justice is not always convenient. It is not always quick or easy or cheap, but it matters. It matters that people who break the law face consequences. It matters that fraud is punished. It matters that property rights are protected, even when it is one individual against an organization with resources and lawyers. The Timber Trespass Act in Georgia exists because the legislature understood that trees have value, that forests are assets, and that stealing timber is real theft that deserves serious penalties. Triple damages might seem harsh until you consider that it takes 50 years to grow a mature oak and 3 minutes to cut it down. The law has to account for that disparity. In my case, the triple damages were not just compensation, they were a statement. The statement was that you cannot steal 50 acres of timber, forge documents to cover your tracks, and expect to get away with it. The statement was that HOAs do not have unlimited power and cannot simply do whatever they want. The statement was that individual property rights still matter, even in the face of organized opposition. By the summer of my second year post-verdict, the saplings were knee-high, and the property was beginning to look less like a wasteland and more like a young forest in progress. I had also planted wildflowers between the trees, adding color and helping to prevent erosion. The result was actually quite beautiful in its own way, different from the mature forest I had lost, but promising. Emma and her family visited regularly, and my grandkids loved exploring the property, tracking the growth of specific trees they had adopted as their own. My grandson Tyler, who was 8, had picked out a young oak near the cabin and insisted on measuring it every visit, recording its growth in a little notebook. "This is going to be huge someday, Grandpa," he would say with absolute certainty. "It will," I would agree, "but it will take time." "That is okay," Tyler would say. "Good things take time." Out of the mouths of babes. I also started writing about my experience, putting together a detailed account of everything that happened, all the legal processes, all the strategies that worked and did not work. Michael thought it could be helpful for other property owners facing similar situations, and a small legal publisher expressed interest in turning it into a handbook. I spent my evenings working on the manuscript, trying to turn my personal nightmare into something educational and useful. The writing process was surprisingly therapeutic. Putting everything down on paper, organizing it into a coherent narrative, helped me process the trauma of coming home to find my forest destroyed. It gave me a sense of purpose and closure. One afternoon in late August, I was working on the manuscript when I heard an unfamiliar vehicle coming up the drive. I tensed instinctively, old habits from the whole HOA debacle still making me wary of unexpected visitors. But when the truck came into view, I relaxed. It was a Forestry Service vehicle from the state. A man in his 30s stepped out, wearing a ranger uniform and carrying a clipboard. He introduced himself as David Chen, a state forester who had heard about my case and wanted to see the reforestation project firsthand. "I hope you do not mind me dropping by," he said. "I read about what happened, and I have been curious about how the replanting is going. This is one of the larger private reforestation projects in this part of the state." "Not at all," I said, genuinely pleased. "Would you like a tour?" We spent the next hour walking the property, and David examined the saplings with a professional eye, asking about species selection, planting density, and long-term management plans. He was impressed with what I had done, calling the project thoughtful and sustainable. "You know," he said as we walked back toward the cabin, "the state has grants available for private reforestation projects, especially when they involve native species and ecological restoration. You might qualify for some funding to help with ongoing maintenance and expansion." That was news to me. David spent another hour explaining various state and federal programs designed to support private landowners who were engaged in conservation and reforestation. By the time he left, he had given me a stack of brochures and application forms, as well as his card with an invitation to call if I had questions. I applied for 3 different grants over the next month. 2 were rejected, but the third came through, a $15,000 grant from the Georgia Forestry Commission to support native species reforestation. The money would cover several more acres of planting and help with maintenance costs for the existing saplings. It felt like the universe was finally giving back after taking so much away. As fall arrived and the saplings began their second dormancy period, I found myself reflecting on everything that had happened over the past 2 years. I had lost 50 acres of mature forest, endured months of legal battles, testified in multiple trials, and become an unlikely advocate for property rights and HOA reform. But I had also won a $500,000 judgment, sent criminals to prison, helped change state laws, started a successful reforestation project, and turned my experience into something that could help others. It was not the path I would have chosen, but it was the path I had walked, and I had walked it with integrity. The forest would grow back. It would take decades, but it would happen. And when my grandchildren were my age, they would walk among those trees and maybe tell their children the story of how the forest was stolen and then restored, how their grandfather fought back against injustice and won. That story would be worth telling. On a crisp October evening, almost exactly 2 years after I had come home to find my forest destroyed, I stood on my porch with Michael Rodriguez, who had driven up to see the property and celebrate the anniversary. We had become friends during the long legal battle, and he had taken a personal interest in the reforestation project. "You know what amazes me?" Michael said, looking out at the field of young trees. 2 years ago, this looked like a disaster zone. Now it looks like hope." "That's a poetic way of putting it," I said. "I am serious. You could have given up, taken the settlement, let them get away with it, but you did not. And now look at what you have. New trees, new laws, real justice. How many people can say they actually made things better?" "I just did what I had to do." "That's what everyone says who does something extraordinary," Michael replied. "They just did what they had to do, but most people do not. Most people take the settlement, sign the NDA, and move on. You did not." We stood there in comfortable silence for a while, watching the sun set through the young trees. The light filtered through the saplings differently than it had through the mature forest, more open and golden, but still beautiful. "Do you regret any of it?" Michael asked finally. I thought about the question carefully. Did I regret the stress, the sleepless nights, the months of legal battles? Did I regret turning down the settlements that could have ended everything more quickly? Did I regret the public scrutiny and the time spent away from normal life? "No," I said finally. "I do not regret any of it. It needed to be done, and I was the one who had to do it. The only thing I regret is that it had to happen in the first place." Michael nodded. "Fair enough. Well, for what it is worth, I am proud to have worked on this case. It is the kind of thing that reminds me why I became a lawyer." We shook hands, and he headed back to his truck. As I watched him drive away, I felt a sense of peace that had eluded me for 2 years. The battle was over. The forest was growing. Justice had been served. I walked down into the field of saplings as twilight deepened, running my hands over the young bark, feeling the life and potential in each tree. These were not the trees my grandfather had planted, but they were my trees, planted with money won through standing up for what was right. Somewhere in prison, Patricia Cunningham was probably regretting her choices. Somewhere in the Cascade Ridge Estates development, homeowners were probably still complaining about the special assessment they had to pay because of her fraud. Somewhere in the state capitol, legislators were probably drafting new regulations inspired by my case. But here, on my property, surrounded by saplings that would someday be a forest, I was at peace. The land had been wounded, but it was healing. The injustice had been severe, but it had been answered. The battle had been hard, but it had been won. I stayed out among the trees until full dark, listening to the evening sounds of the Georgia mountains, feeling the cool air, and knowing that I was exactly where I was supposed to be. The forest would grow. The laws would protect others. the story would be told, and I would be here, tending the trees, protecting the land, and making sure that what happened to me never happened to anyone else who was not prepared to fight back. That was my victory. Not just the money or the judgment or the criminal convictions, but the knowledge that I had stood my ground, defended my property, and won. In a world where HOAs and other organizations often use their resources to bully individuals into submission, I had proven that one person with the truth and the law on their side could still prevail. The Timber Trespass Act had done exactly what it was designed to do: provide real consequences for stealing trees. Triple damages were not excessive. They were necessary. They made the risk of timber theft so high that only the truly foolish or arrogant would attempt it. Patricia Cunningham had been both foolish and arrogant, and she had paid the price. As I walked back to my cabin that night, I made a promise to myself and to the land. I would see this reforestation through. I would tend these trees until they were established and thriving. I would protect this property for my children and grandchildren. And I would never, ever let anyone make me feel powerless on my own land again. The lights of my cabin glowed warm in the darkness as I approached. Inside, I had a life to live, a manuscript to finish, grandchildren to spoil, and trees to tend. The nightmare was over. The forest was growing. Justice had been served. And that, in the end, was all that mattered.